Good morning for those who are all here. My name is Barbara Rosenberg. I'm with ElderWorks Educational Services, and we're happy to have our friends from Shire Law Group, Alan Press and Caren Naidoff, that will be discussing Finance Frenzy, estate planning for senior priorities. Wanted to tell you a little bit about ElderWorks this morning. First of all, this event is being recorded and we appreciate your participation. ElderWorks is a not-for-profit 501c3 whose mission is to provide older adults, seniors, and families information, referrals, and guidance for senior living, home care, and support services to help make appropriate decisions. This includes education on topics for community members and professionals. The guidance we provide will help seniors stay home well or transition successfully into new senior housing opportunities. If you have any questions throughout the presentation, please use the chat button, and I will be screening those questions, and we can, where necessary, I can poach in and ask Alan and Caren to answer those questions. We really appreciate your time and enjoy. So without further ado, I'd like to introduce Alan and Caren.
Good morning, everybody. Thank you, Barbara, for that introduction. My name is Caren Naidoff.
And I'm Alan Press, and we're partners at Shire Law Group in Lincolnshire, Illinois. And we're very happy today to present Finance Frenzy, estate planning for senior priorities.
So as Barbara mentioned, if you have any questions, drop them into the chat box. We love to get your questions. We want to make sure that you understand all the material that we're covering today. If at some time in the future or after the presentation, you have some questions that you want to ask us directly, give us a call or send us an email. We're always available. You can call us at 847-955-9000 or send us emails at Caren, that's Caren with a C, C-A-R-E-N at shirelawgroup.com or Alan, A-L-A-N at shirelawgroup.com. So with that, we're going to get started. So today, what we're going to be talking about: money personality, money partnering, money managers, money envy, money priorities for seniors, and planning for seniors. And we're going to take each one of these topics one at a time. And we're going to start out with money personalities. So an individual's way of thinking about money is shaped by how we were raised, what our education is, our individual experiences. There are 5 types of money personalities. The first type is the money hoarder. So while others see money as a means to buy nice things, the money hoarder sees it as a means to obtain security. So no matter how much money a hoarder has, they're always going to fear that one false move or unexpected disaster might make them poor. And here you can see this little image of a popcorn, BYOP, bring your own popcorn, trying to save some money there. Money spenders, the second type of money personality, enjoys spending money and gets immediate pleasure from buying themselves goods and services. So they may spend most or all of their money rather than savings. So here you see this image of somebody who obviously likes to purchase pocketbooks or purses. The third type of money personality is the avoider. So the avoider is not comfortable with money. They may not even know how much is in their bank account, and they don't really stay informed about their money. Fourth type of money personality is the money monk. The money monk feels that the desire for money chips away at people's moral values, and they identify with people of modest means rather than with those who amass wealth. And the last type of money personality is the amasser. The amasser is happiest when they have large amounts of money at their disposal to spend, to save, and or to invest. So a lack of money may lead to feelings of failure. And money personalities sometimes overlap one another, so you might not fit perfectly into one type of personality. There might be elements from a few different personalities. So avoiding differences in money personalities is important in order to set your goals. It's important to understand one another's money personality and to set concrete, unified financial goals despite these differences, to settle on expectations of how to handle finances up front, and then to sit down and plan out what your needs are, as well as sitting down and planning out what your priorities for those needs are. And then to reach agreement with all those that are going to be involved in how your prioritized financial goals are going to get met. So money partnering is all about recognizing that finances often create struggles over power and control. So it's very important to have full transparency as to available funds upfront and being in unison as to priorities and what funds are necessary and essential to meet those priorities. So somebody has to be appointed the money manager, and it might be yourself. And the money manager needs to be realistic and in agreement as to who that person should be. So the money manager has to be able to manage differences in these money personalities so they can have a common prioritized goal or goals. And the money manager has to have a clear understanding of your net worth, your budget, and your investments to help ensure that the funds you have allotted for those priorities are realistic, that they're going to work. And to that degree, they have to be able to reshuffle those finances to accomplish your goals when that's necessary. So sometimes you might want to consider appointing an outside money manager. And that outside money manager has to have that clear understanding, again, of your net worth, of your budget, of your investments, so they can help ensure that the funds that you've allotted for your priorities are realistic. And again, be able to reshuffle finances to accomplish any kind of goals that you might have. Should be somebody who's objective. And this would be somebody like a professional financial advisor or a certified financial planner. So one thing that is easy to do and you want to avoid doing is falling into the trap of being green with envy over another family's apparent wealth. So your finances are what matters, and getting them in order are going to give you the confidence and the way you are respecting your unique financial profile and your unique goals. So how we put it all together for money priority for seniors is that every stage of life is going to require an authentic look at your finances. So you need to determine what your present priorities need to be and to determine what your future priorities need to be to the extent possible, right? We can't provide for everything that's going to happen in the future. We don't know what's going to happen, but there's some things that you can plan ahead for that you can put in place. So you want to have your money manager coordinate your finances with your priorities while they're managing differences in money personalities, so they can ensure that everyone is money partnering to achieve the financial goals necessary to set those money priorities and to achieve your unique senior planning presently and in the future. So senior planning is important. As seniors, it's essential to create a healthy balance between enjoying your senior years and savings should you need assistance with things like activities of daily living. So if you haven't planned for disability, now is the time, and we're going to talk about that in detail. And planning in advance is going to provide huge savings and peace of mind in comparison to being reactive to a crisis. And Alan will touch on that in the presentation as well. Estate planning is an important means to plan for and accomplish your senior planning priorities. We're going to spend some time talking about that this morning. So a review of estate planning documents and how it coordinates with those senior priorities, we're going to start out with. So the basics. What is estate planning? So estate planning is the process of using an attorney to help you prepare for your future by planning for who you want, your wealth and your assets and your property and more to be gifted to after you pass away. And the people that you're gifting to are known as your beneficiaries. But in addition for planning who you want your wealth, assets, property to be gifted to after you pass away, it's also importantly about planning for how you want your wealth, assets, property, and more to be gifted to after you pass away. Importantly, estate planning is also about directing your healthcare and guiding your finances during your lifetime. It's about minimizing or avoiding taxes and minimizing or avoiding probate. And probate can be time consuming and expensive. And Alan is going to dive into that a little bit as well this morning. So the ideal senior estate plan, this is what it would look like. You'd have a last will and testament or a will, or perhaps you'll have a living trust with a pour over will. Importantly, you could have a power of attorney for property, a power of attorney for healthcare, a HIPAA authorization, a living will declaration, and we're going to discuss all of those this morning. Assignments and deeds, your beneficiary designations are going to be taken care of. You're going to think about long-term care planning, possible irrevocable trusts, and finally, a roadmap of your estate plan. And we'll touch on all of these this morning.
Okay, sorry, skipped a few slides there. There we go. Okay, so first we're going to start off with a last will and testament. And this is something that probably is familiar to most of us. We see that on TV when somebody passes away, you know, everyone sits in a room and an elderly lawyer will read the will to everybody and they can find out what they're receiving. It's not quite as dramatic as that, but a will is a document where you can set forth what you want to have happen to your assets after you pass away. We're using the phrase last will and testament. It could also simply just be called a will. It's important to note that a will is only going to be effective at death. And this will become important later when we contrast this to a trust. So if you are in an accident and you're in a coma in the hospital, a will is not going to do anything for you because it doesn't go into action until after somebody passes away. If you have minor children, a will could allow you to designate who you want to have as the guardian of your minor children. And a will is also going to instruct the court as to who you want to receive what when it comes to your assets and property. So I did just mention probate there. Let's just take a quick look for a moment on what is probate. So probate is the legal process of administering an estate of a deceased person to resolve not only claims, but to also distribute their property. So if I pass away and I owe Caren $10,000, she probably wants to collect that $10,000 from my estate prior to the assets being distributed out to, let's say, my family in accordance with my will. So she could file a claim with the court and state that Alan Press owes me $10,000 and I'd like his estate to pay that to me before the estate is distributed to his family. So that's how a probate court works. And we did use the word estate. And what is exactly an estate? Well, that's just a legal entity that's going to be created when you pass away. And that could include different things, different assets like your money, your accounts, cars, a home. You could have assets in a trust. You could have assets jointly with other people. And we're going to take a look at all of those examples as well. So when is probate necessary? There is a common misconception that if you have a will, you're going to avoid probate, and that's not necessarily true. That may be true, but having a will does not necessarily mean that you're going to avoid probate. You're going to need probate when you have probate assets, and we're going to discuss what that is, that in the aggregate are going to exceed $100,000. So what are these probate assets? Well, basically, they're assets that you're going to own in your own name without anybody else, that don't have a beneficiary designation and aren't held in a trust. So anything that you see on this screen is going to be able to avoid probate. So those are assets that are held in trust, and we're going to talk about trust in a little bit. Any assets that you might own in joint tenancy or tenants by the entirety. So if I have a joint account with my son, when I pass away, that account will automatically transfer without probate to my son because he's a joint owner. Like what if I had in that situation, what if I had a will that was leaving everything to my wife? Who gets that account, my wife or my son? Well, in that example, my son would, because the joint tenancy is going to take precedence over whatever a will is going to say. Also, any assets that would have a beneficiary designation, like a retirement account or maybe a life insurance policy. So I might have a life insurance policy that says when I die, I want the insurance company to pay the death benefit to my daughter. So that's a contract that I have with the life insurance company when I bought the policy. So they're automatically going to pay my daughter the death benefit upon my death. All she'll have to do is contact the insurance company, let them know that I passed away, and perhaps provide a copy of a death certificate. And then the insurance company will pay her directly. That does not go through a probate proceeding. Also, anything that has a pay on death or transfer on death designation. So I might have a bank account owned in the name of Alan Press, POD, or payable on death, to Ethan Press, my son. So then he would, upon my death, be able to be the owner of that account. So these assets do not need to go through probate. If I have a bank account that's only in my name and it has no payable on death, it has no beneficiary, I pass away, if assets like that are going to be in the total above $100,000, then a probate is going to be needed. Okay, so if probate is, let's say those assets don't total over $100,000. Let's say I just have that one account and there's only $50,000 in there. There's something called a small estate affidavit. So an affidavit may be used in lieu of a probate proceeding in order to transfer that account, because the total of my probate assets is going to be under $100,000. We will point out, however, that the small estate affidavit is not, does not cover anything having to do with real estate. So what happens though if somebody passes away and they have probate property, but there is no will? When this happens, that person has died intestate. And lo and behold, the state of Illinois has a statute that states who is going to receive this property when somebody passes away. So again, this won't apply to anything that has a beneficiary designation or any joint accounts. Those are not probate property, so that this law would not affect those things. But let's go back to that bank account that I own that I own in my own name, and there's no beneficiary designation. If I don't have a will, who gets that money? So briefly, the Illinois law is as follows. Each state, by the way, would have different laws. It would depend on where the person resided or lived at the time of their death. And I live in Illinois, so this would apply to me if I didn't have a will. If I am survived by a spouse and descendants are really just children and grandchildren, then the spouse is going to receive 50% of the property and the children are going to get the other 50%. If I'm survived by only a spouse and no children, then the spouse gets everything. If I'm survived by children and no spouse, then the children would get everything. If I'm survived only by parents or siblings, then the parents and siblings are going to get the money. However, if one parent is deceased, the surviving parent is going to get a double share. And if I'm not survived by parents, brothers, sisters, or descendants of brothers and sisters, the estate is going to be split equally between the maternal and paternal sides of my family. And if I'm not survived by anyone, like there's no one to take it, then the property is going to go to the state of Illinois. So if I wanted to leave the property to my neighbor, and that last situation is, let's say I have nobody, no family whatsoever that is living, then the money would go to the state of Illinois. It would not go to my neighbor. I would need a will that says the property should go to my neighbor. So if there's no will, there's also no executor. So if you die without a will, you're intestate. So the court needs to know who's going to be in charge. So anyone who's an interested person, that's going to be basically the close family member, so a spouse or children or brother and sister or parents are going to be able to file a petition to be appointed the administrator of the estate. So if there's a will, the person who runs things is called the executor. If there's no will, the person is called the administrator, but the person who wants to be the administrator needs to petition the court and get that appointment. And then anyone else who's an interested person might have the ability to either consent or object to that, depending on these intestacy laws. So let's take a look at the ways that a last will and testament coordinates with senior priorities. So while a will does not avoid probate, it is going to streamline the process. One of the best benefits of having a will is that in the will, you can state that your executor does not need to purchase a bond. And this is very important because if you don't have a will and you die intestate, in addition to petitioning the court to be designated as an administrator, the court is going to require that the estate purchase a bond, basically like a surety bond, to make sure that the administrator is going to follow the law. These bonds can be very expensive, and if they could be avoided, that typically is going to be considered to be a benefit. So avoidance of the bond is a great benefit of doing a will. A will is going to allow you to choose who you want as your executor. So you don't have to leave it up to chance for family members to try to become the administrator of your estate. Will is going to avoid property distributions that you never intended, like ones that are under the statute. If you recall, if there is a spouse and children, that means that 50% of the assets go to the spouse and 50% go to the children. So it sounds like that might be okay, but that could in practice create some problems. I had a client where husband and wife owned a home. Husband passed away and didn't have a will. And the husband owned the property in his name alone. He passes away, and everyone believes that his intent would be that the wife would receive the house. However, the house was distributed 50% to his spouse and then 50% to his children because he didn't have a will. So we had to have a probate for the husband. And then because the kids were minors, we had to have 2 additional separate probate proceedings for guardianship for the minor children, because minors can't inherit assets or property. There needs to be a legal structure to handle that. And guardianship is a whole separate topic, but that situation required 3 separate probates to open up, and that could have been avoided if there was a will. And remember that wills are only effective upon death, and therefore don't have the ability to plan for disability. It can only help you plan for what happens at your death. So let's switch gears to trusts now for a few moments. There is a common misconception that trusts are only for the very wealthy. This is not true. We have lots of different clients with lots of different financial means, and trust can work well for many different types of clients. They're not for everybody, but they can work in many, many situations. So what is a trust? A trust is a legal document that you create during your lifetime. It's going to help you streamline the administration of your assets during your life and after death, because the trust is going to be effective immediately upon signing. So the trust does not kick into action only after death. It's effective immediately. So it could be a tool to be used to plan for potential incapacity or disability, as well as planning for what you want to have happen after death. A will is also going to provide, a trust is also going to provide privacy because there's no probate proceeding, there's no court proceeding. Everything remains private. With a will, especially if there's a probate, that's all going to be open to public inspection. I can go down to the courthouse, take a look at if my neighbor passed away, take a look at their probate file, see what money they had, see who it's going to, see who they owed money to. With a trust, you're keeping everything in a private situation because there's no court proceeding. It doesn't need to get recorded or filed anywhere. A trust is also going to provide maximum control even after you're deceased. So if you have beneficiaries, that have, let's say, bad spending habits, and they can't be trusted with receiving a large sum of money when you pass away without some sort of structure or control. A trust is going to be able to provide that. So that becomes a big factor for people when they're deciding to do a trust. A trust is also, because it doesn't go through probate, it's going to avoid that cost. It's going to minimize and reduce the amount of time that you need to spend hiring lawyers. And nothing, of course, nothing against lawyers, but part of planning is going to be, trying to engineer some savings and some streamlining of the process, so your family doesn't have to spend as much money. And a trust is going to be able, your trustee, to carry out your wishes exactly the way that you designated. So you can get very granular with the way you want things to happen, even after death, and of course, during disability. So let's take a look at some trust terms, just so we can become familiar with them. The person who creates the trust can be called the settlor or the grantor or the trust maker. We use the term grantor in our office, but these are all interchangeable. So that's the person who creates the trust. The trustee is the person who's going to control the trust. So this is the person that's going to manage everything. Now, can the trustee be the same person as the grantor or the creator of the trust? Of course, and that happens all the time. We have clients that come in and they want to create a trust, but they want to maintain control over that trust and their assets during their lifetime. So it's a very common scenario. They may designate successor trustees. So when they're unable to continue as the trustee of their own trust, they have somebody set up to come in and take over for them. The next term is beneficiary or beneficiaries. These are the people that receive the benefits of the trust. Can that be the same person as the trustee and the grantor? Yes, again. So that's a very common situation. Again, I might create a living trust during my lifetime. I want to be in control, so I'm the trustee. And during my lifetime, I also want to be the beneficiary, because if I want to use or spend my money, I want to be able to take it out and spend it. So I'm the grantor, I'm the trustee, and I'm the beneficiary. I can be all three of those things. And of course, I can have successor beneficiaries. So after I pass away, I can have a group of people that I designate as the beneficiaries. So the beneficiaries can change within the time frame of a trust. These are certain things that are true about trust. They're going to give you control over your assets. Trusts need to be funded. This is very important. We have a lot of people that come in after somebody passes away and they're like, oh, Uncle Fred passed, but good news, he had a trust. So we take a look at the trust and the trust looks great, but none of Uncle Fred's assets were actually in the trust. So nobody took the time to fund it. So when you're dealing with estate planners and you're putting together your estate plan, you want to make sure that all of your assets are set up in the correct way to make sure that they're going to work with your plan, whether that's going to be a will or a trust, or you're going to rely on, beneficiary designations or whatever you're going to do. A trust is going to avoid probate. We've already talked about that. Trusts are private because they avoid that probate. We've already talked about that. And trusts are going to be easy to administrate, simply for the reason that they don't require any court intervention. So, the trustee is typically given the latitude and the discretion to do what is necessary to help the beneficiaries get what they need from the document. So it is easier to administrate. And then we also have what's called a pour-over will. So even if we do a trust for a client, let's say they don't get all of their assets into the trust for some reason, or they get an asset later on down the road and they forget to put it into their trust. A pour-over will is just a backup document that's going to allow any assets that are in the estate to pour over into the trust. Looks like we do have a question. Is there anything, this is a great question, is there anything that cannot be funded into a trust? And the answer is yes. So certain assets like retirement plans, like an IRA or a 401k, those have to be owned by individuals. They cannot be owned by the trust. However, an estate planner will help you design your beneficiary designation so those types of assets will work in conjunction with your trust. So the trust could be named as a primary or contingent beneficiary of your trust, So again, you want to work with someone who can help you navigate that and make sure that the assets are set up correctly. Let's go on to the next slide then. All right, so ways in which a trust coordinates with senior priorities. A trust is going to give you peace of mind that you've provided for your family, and that in a way that's going to meet your unique goals and desires. A trust is going to allow you to plan for how you want that money to go to your, let's say, your children or your other beneficiaries. Maybe there are people that are bad with money. Maybe you're concerned about creditors that they may have, or maybe they're married to a spouse that, they might get divorced, and you're concerned that, if you leave money to your child and then they got divorced, that the divorcing spouse will take, half the money with them. These are things that could all be addressed throughout an estate plan, so they coordinate with senior priorities. A trust is also going to avoid having property distributed in a way that you didn't intend. It's going to avoid probate, and it's going to allow you also to address a whole bunch of other issues by making sure that your family is going to receive exactly what you intend them to receive and how you intend them to receive it.
So let's talk about planning for disability. This is a very, very important part of planning for priorities and planning for not only the present, but the future as well. So what happens if you become incapacitated? So there's a few estate planning documents that you can include when you do your estate plan for that specific purpose of planning for disability. One is a revocable living trust, which Alan just discussed. Another document, and we're going to go through each of these documents in detail, is a power of attorney for property, healthcare powers of attorney, a HIPAA authorization, the declaration for mental health treatment, the living will declaration, and the DNR, or the do not resuscitate. And you'll see that some of these documents have asterisks next to them. That healthcare power of attorney, the HIPAA authorization, the declaration for mental health treatment, the living will, and the DNR. And all of those documents are health-related medical documents that make up what is known as your advance directives. So let's break down all of these different documents one at a time. And importantly, it's important that there's an understanding that these advance directives and that power of attorney for property must be created while you are still able to make decisions for yourself. So you can't create these powers of attorney and healthcare directives after some type of injury or illness is going to prevent you from making your own decisions. You have to be mentally competent to create your powers of attorney and healthcare directives. And that is why it's essential that you put them in place prior to something unexpected occurring in the future where you wouldn't be able to create these documents for yourself. So we're first going to take a look at that power of attorney for property. And when you think about property, think about more than real estate, but anything financial. This is also known as a financial power of attorney or a durable power of attorney. When we draft these documents for our clients, we call them powers of attorney for property. This is a written document in which you give someone the power to make decisions on your behalf about your property and your finances if you become unable to make these decisions yourself. And you can draft your power of attorney for property to become effective not only upon incapacity, if you're unable to make financial decisions, but also for convenience. So if you're traveling and you're unable to attend to a particular financial matter, if you draft your power of attorney for property in a way that it's effective immediately or for convenience, the person that you are authorizing to step in on your behalf and help out with your financial affairs can go ahead and do that. They don't have to wait until you become incapacitated. So the power of attorney for property has some nice flexibility there that you can use it to plan not only for incapacity, but for convenience as well. The next document is a medical document, healthcare power of attorney. This is also known as a medical power of attorney or a healthcare proxy. And again, when we draft these for our clients, we call them a healthcare power of attorney, but different names for the same document. And this is a written document in which you give someone the power to make decisions about your healthcare on your behalf, but only if you become unable to make or communicate these decisions yourself. So none of these documents that we're talking about this morning supersede your right to make your own decisions or to have control of your finances or your medical. But if you're unable for some reason to make your own medical decisions, it's extremely important that you have this healthcare power of attorney in place. And in the healthcare power of attorney, you will authorize the agents, again, people that are allowed to step in on your behalf and make medical decisions when you can't make your own. For your powers of attorney in Illinois, only one agent can act at a time. So you'll list the people who you're authorizing to step in on your behalf. If the first person your list is unable to step in, then they'll go to the next person, then the next person. It doesn't mean that all these people can't talk to one another and coordinate with one another, but they're going to look to one decision maker at a time. And that's going to be to the first one listed, and then they'll go down that list. The next healthcare document, the advanced directive, is your HIPAA authorization. This is the Health Insurance Portability and Accountability Act. And this is a written document that allows healthcare providers to release and share medical information with people that you designate to receive that information on your behalf. So those people that you designate are your authorized recipients who you're saying it's okay for them to get medical information about me. There's no hierarchy on your HIPAA authorization. You can list as many people as you want, unlike your powers of attorney. Anybody listed on your HIPAA authorization is going to have the same ability to gain access to any kind of medical information should they need it. And the HIPAA authorization is important because you might say that I go to my doctor's office and I fill out a HIPAA authorization at my doctor's office. Well, typically that HIPAA authorization that you're filling out at your doctor's office is for that particular provider. But what happens if you end up in an emergency room and at the time you enter, you're unable to communicate who should be contacted? At that point, you need this HIPAA authorization for those people that are authorized to be able to call that emergency room and to find out what's going on.
Caren, real quick, just to interjecting a question, talk about authorization and people that are allowed powers of attorney for healthcare, that kind of thing. Somebody asked if a nonprofit organization is allowed to be a beneficiary, for example, if relatives are deceased.
I guess that goes back to the trusts and the wills. And yeah, the answer, of course, is yes. So we do that frequently. People might want to leave a small gift to a nonprofit or a charity, or of course, that profit or that nonprofit or charity could be a much larger beneficiary or even the sole beneficiary of your estate plan. So that is completely allowable. That typically does not create a problem at all.
And to that point, when we draft these trusts for our clients, every client's unique. Everybody has a different goal and different wishes and things that they're passionate about in a nonprofit that they might be passionate about. And that's what the documents allow you to do. It allows you to capture these things so you can make sure that your wishes are seen through in the way that you want them to be.
Yeah, and then just to follow up on that, thanks, Caren, is also you could designate even how, and most of the charities prefer to receive the money unrestricted, but you can place restrictions or direct, under what sub-program of the charity you want the money to be used for. Like if you're leaving the money to a school and you want it to be used towards, let's say the badminton team, you certainly can designate that as well. So you can get very specific on how you'd like the money to be used.
All right, so going back to these healthcare directives, the next healthcare directive is a declaration for mental health treatment. And this allows you to choose whether you want to receive electroconvulsive treatment, ECT, or psychotropic medicine if you have a mental illness and you're unable to make decisions for yourself. So you can write your wishes or choose someone to make your mental health decisions for you. This is an optional declaration that they have in Illinois if you wanted to make that part of your estate plan. And the next is a living will. This is confused often with your last will and testament, or that will that Alan talked about, or a living trust, because sometimes it's referred to as a living revocable trust. And Alan touched on that as well. The living will is actually a healthcare directive. And when you go to the hospital and they say, do you have a living will, or do you have a living will declaration? This is what they're referring to, this healthcare directive. And it's a legal document which states your wishes regarding life support in the event you are in a persistent vegetative state, a reversible coma, and you cannot communicate your wishes. So if you agree with what the living will declaration states, which is if I have an incurable or irreversible injury or disease that's considered to be a terminal condition by my attending physician, I want to be able to die naturally. That's the gist of it. It's very specific language. If you agree with it, you would then put the living will declaration in place as part of your healthcare directives. And then DNR, there's a lot of confusion around DNR. DNR stands for do not resuscitate. People come in all the time and say, I want to put a DNR in place. It's actually a medical document. It's a medical document or order which tells doctors not to restart your heart or breathing. So normally a doctor or a first responder is going to give CPR when you stop breathing or your heart stops. The DNR must be signed by your physician. So you don't want a DNR in place unless you would not want someone to restart your heart or breathing. So this might be something that somebody who has had 5 heart attacks, and if they had one more, they just would not want to be resuscitated, or they're at the end stages of a terminal illness, they might want to put a DNR in place. Did we miss one or?
I'm sorry, Caren.
No worries. So the ways in
bad clicking finger today.
Yeah,
sorry.
Alan has the tough part. He's the one who has to go through the slides. I have the easy part. So the ways in which powers of attorney and advanced directives coordinate with senior priorities, well, they allow you to appoint the agents, those people who you want to step in on your behalf for your financial and medical affairs. So upfront, you're able to make those choices. They provide direction as to life-sustaining treatment and other personal choices. So in your power of attorney for healthcare, you can make some decisions there about life-sustaining treatment, as well as that living will declaration that we talked about. They ensure that you provide specific powers for your agent, so they're not prevented from acting on your behalf in accordance with your wishes. So in Illinois, if you don't list specific powers, your agents or those people that you are choosing to step in on your behalf might not be able to utilize those powers. So we add pages and pages and pages of additional powers into our powers of attorney. So just in case your agent would need to use one of those powers, they could. So we add things like gifting, and we do a little long-term care planning as well. They also allow you to decide who's authorized to get your protected health information, that HIPAA authorization. So if you need to, you can make sure that you have everybody listed that if you were in an emergency room, you would want them to know what was happening with you. You can also, through these, give your agents decision-making ability while you have that mental capacity to authorize agent power. So again, it's very important that you do these upfront before a crisis occurs.
There was a question regarding the interplay between a DNR and a medical power of attorney. So does a medical power of attorney cover DNR when you do not want to be resuscitated? So those are two different documents, obviously. And the DNR, I always think of it being more relevant, like if something were to happen to you and the paramedics come, and they know that you're DNR, that they're not going to resuscitate you, where the medical power of attorney is a little bit more of an expansive document. So in the medical power of attorney, you're able to make a designation that you don't want to be kept alive if you're in a vegetative state and there's no chance of recovery. So these are related topics, but the forms technically handle slightly different situations. I think I look at it like the healthcare power of attorney is more broad in its scope. So it appoints a decision maker that you're comfortable with, that's going to make the right decision regarding your life-sustaining treatment. Whereas the DNR is a document that, if you're in a hospital, your medical staff is aware that you're DNR, and that if you go into heart failure, that they're not going to attempt to restart your heart at that point. So that's kind of the difference, if that is clear.
And remember that DNR is a doctor medical order too.
Right. Right. That's a great point. The healthcare power of attorney is a document that you create yourself, usually with the assistance of an attorney. The DNR is a document that you come to decision with your medical provider. So it has to be signed by a medical doctor to be valid.
I want to make the point too, and I'm showing my face again real quick on this one. Very important that these documents, whatever you choose to do, some people put them on the refrigerator, some people put them in the refrigerator, some people put them where they can be seen in the home. So these are things that should not be locked up in safe deposit boxes. They should not be hidden. And you should have a trusted member of your family or friend, maybe perhaps that has copies as well. So make these forms known, your DNR, your power of attorney for healthcare, power of attorney for property. So I just wanted to say that because a lot of times people think these things need to be locked up, and to the opposite. Please, if you have a paramedic come to the house, it's always very helpful. They're going to look to the refrigerator. That's where they're going to look.
And we think that all adults should have a healthcare power of attorney. A DNR, though, is going to be very specific to your situation. We have a lot of clients that come in and they're like, they're in their 40s and they're healthy, and they're like, oh, well, we need a DNR. They don't really want a DNR, because if they had a heart attack, they would want to be resuscitated, most likely. So again, it's for people that are more end stage illness and really don't want to be resuscitated. So you wouldn't want a DNR unless you're in, typically very bad medical shape and you just don't want to be resuscitated anymore.
And to Barbara's point, when we do these documents for a client, we have a estate planning portfolio binder, and in there we have tabs and we have all the documents. And we always say, put this binder someplace in your home that's easy to access. Tell somebody where it is. Whoever needs to know, tell them where it is. Should something happen, they know exactly how to access it. We have originals, we have copies in there, but we also give electronic copies to our clients. And then often our clients will say, to Barbara's point, the powers of attorney, can you please give those to my kids, and the HIPAA, because they're listed in there and I want them to have it. So back to that emergency room that you're in. If you're in that emergency room and your child has your HIPAA authorization and wants to get information quick, they can use the electronic copy. They don't need to have an original. They don't need the copy. They can use the electronic copies. They all have the same effect and force. So that's going to be the best way to get information very, very quickly, is through those electronic copies. But you want to make sure that these documents are in a place that somebody can easily access, and they know where they are and they know how to get to them. So we always like to bring this up too, because we find that a lot of people are unaware that right at your fingertips, you have this great resource. And this is the Medical ID app. If you have an iPhone, you'll see this icon. It's a white box with a red heart in it. If you have a different type of smartphone, you can download a similar Medical ID app. And the Medical ID app allows first responders to get through any kind of lock screen, whether it's facial recognition or any kind of code, and get into whatever information you've placed into that app. So this is extremely important if you have any kind of allergies to any kind of medication, if you have any conditions that a first responder would need to know, if you have any kind of food allergies. So whatever you feel would be useful and helpful, you could place into that Medical ID app, and then somebody who would be a first responder on a scene can go ahead and bypass your lock screen, get right in there, and have valuable information immediately.
Okay, so now we're going to switch over to planning for long-term care. So before we start this discussion, just wanted to point out that the documents that Caren went over, the power of attorney for property, the healthcare power of attorney, the HIPAA, the living will, these are the most essential documents that when you become a senior, we recommend these for all adults, including very young adults, but those are the most important documents. So as a foundation for any plan, you want to have those powers of attorney and those medical directives in place. And you want to make sure that they're drafted to provide for if things were to go bad for you health-wise in the future, that someone's going to be able to pick those up and be able to assist you. So let's take a look at planning for long-term care. 7 out of 10 people over the age of 65 at some point are going to need long-term care. You know, what is long-term care? Well, generally there are these activities of daily living, transferring, bathing, continence, dressing, using the toilet, and eating. And typically when you need help with any of these activities of daily living, you may need some type of long-term care. In addition, if you have a cognitive impairment, that would also indicate a possible need for long-term care. So something like Alzheimer's disease or dementia. So where can you get long-term care? Well, you can get care at home. You might get care in an assisted living facility, or you might need care in a nursing home facility. And then how can you pay for this long-term care? Well, of course, private pay is available. So you pay for your care out of your own financial means. And this is where the beginning of our discussion, when we talked about money personalities, and Caren went through extensively on, you know, developing goals and making sure that your priorities are taken care of. You may want to consider making planning for long-term care one of your goals and priorities. So if you're able, if you have the financial means to be able to set aside money, you know, when you're younger and as you're getting older, to pay for this possibility, that's always a good plan. There's also the ability to purchase long-term care insurance. Traditional long-term care insurance would be one where, you know, you're paying, let's say, an annual or a monthly premium. And if you need long-term care, then the insurance company is going to pay for that for you. That's typically going to be use it or lose it. So if I have a long-term care policy and that I'm paying on each month, and I get hit by a bus and I'm no longer around, the policy of course terminates, but they don't pay any money out because I never utilized any long-term care. They also have things now that are asset-based or hybrid policies. So you could have perhaps a life insurance policy or an annuity that, in addition to a death benefit, might allow you to utilize a portion of that death benefit during your lifetime if you need long-term care. So these are things that you can check with your financial advisor or your insurance person to see what's available and to see if that makes financial sense for you. Medicaid may also be available to you if you have no assets. So Medicaid is for people that have basically no money. Your assets have to be usually below $2,000. So Medicaid is for people that don't have any assets. There is the ability, if you have assets, to plan for being able to utilize Medicaid earlier and perhaps save some of your assets. And we'll touch upon a little bit of that here as well. And then also, if you were a veteran, if you served in the armed forces and you meet certain conditions like serving during any period of wartime, you might be able to receive a veteran pension benefit, commonly known as aid and attendance. And this might be available to help pay for long-term care as well. This is something different than service-connected benefits. So if you served in the military and you had an injury that you're receiving a service-connected benefit for, this is something different. This is more of a pension benefit meant for seniors who were veterans or are the spouses of veterans. So according to 2019, we probably need to update that, Caren, a few years now. The median cost in the Chicago area for in-home care is just under $5,000. The same for assisted living. adult daycare. Let's say, that's typically going to be popular with someone who might have mild cognitive impairment like dementia, is around $1,600 a month. A nursing home could be as much as $8,200 a month in a semi-private room, or $9,200 a month in a private room. And certainly in the area that we're in, we've seen prices that are much, much higher than these numbers. The important thing to note is that most general estate planning was going to ignore planning for long-term care. So if this is something that you want, that you're concerned about and you want to plan for, you should talk to your estate planning attorney or your elder law attorney to make sure that these issues are being addressed for you. So let's take a closer look at Medicaid. Medicaid is only available for nursing home care. It's not available typically for a lower level of care like assisted living. It needs to be a Medicaid licensed facility. Usually it's going to be a semi-private room with up to 2 people in the room, and the facility has to have available Medicaid beds. So each facility, if they accept Medicaid, will have a certain number of Medicaid beds that are available. So if this is a situation where you're looking for placement, certainly ElderWorks is an amazing place to go for resources to help you determine what would be a good placement for particular individuals. But it needs to be, if it's going to be a situation where Medicaid is going to be needed, the facility needs to have a Medicaid bed available. Nursing homes are very expensive. So without careful planning, I mean, of course, despite saving money and being careful during lifetime, it could bankrupt or completely eliminate a family's savings. The government will pay for a nursing home bill with Medicaid if their assets are below $2,000. And if that person is married, the community spouse has no more than $109,560 of non-exempt assets. There are also exempt assets that are available, like a home, especially if the community spouse is living in that home. And then the amount of income for the community spouse or the well spouse can't be more than $2,739, but it also can't be less than that. So if let's say the well spouse is receiving only his or her only income is, $1,500 a month in Social Security, they would be able to receive $1,239 from the institutionalized spouse's Social Security to bring them up to the $2,739. Also, the person who has Medicaid wouldn't be allowed to have more than $30 a month of income. Let's take a quick look at VA benefits. So if you're a wartime veteran or a widow or widower of a veteran and are over the age of 65, you may qualify to receive this benefit from the VA. Aid in attendance is for applicants who require help with with activities of daily living and need financial help. So there's financial requirements, and there's also going to be medical requirements. And basically your unreimbursed medical expenses must exceed your total household income in order to qualify for this benefit. Generally, there's a net worth limitation of $138,489. And there's also a 3-year look back rule for VA benefits. We didn't mention earlier that for Medicaid, there's a 5-year look back rule. So if you have $1 million in your bank account and you know that you're going to need to go into a nursing home tomorrow and you want to qualify for Medicaid, you can't transfer your assets to your kids the night before and then qualify for Medicaid the next day, because there's a 5-year look back rule. So Illinois will take a look at any transfers in the last 5 years. And if there's been any uncompensated transfers or gifts, let's say to children or whatever the case may be, they're going to assess a penalty period wherein you're unable to receive Medicaid during that period of time that would have been covered by the gift. And VA aid and attendance has a 3-year look back rule. So they also have that limitation as well. So for the VA benefit, if you've served at least 90 days of active duty service, and at least one of those days was during wartime, and when you were discharged from the armed services, it was not dishonorable, then you may qualify. But of course, we have these income, expense, asset, and medical condition requirements as well. Spouses or widows of veterans may also be eligible for VA benefits.
So as we've emphasized this morning, long-term care pre-planning is going to be much better than that crisis planning. So Medicaid and VA planning that Alan just discussed, that often comes into play as a crisis type of planning. You want to coordinate planning for long-term care with your family priorities to allow you to evaluate whatever options you might have before a crisis situation occurs. So while you still have that time to plan ahead, these long-term care strategies exist and they should be explored. So estate planning attorneys that concentrate in elder care can discuss which long-term care strategies may be right. Everybody has a unique situation. They can assist with long-term care crisis and asset protection planning if you haven't planned ahead, but the goal really is ideally to plan ahead. And they can provide a strategy that illustrates potentially tax efficient and cost-effective ways to pay for long-term care needs, which, as Alan showed and demonstrated on that chart, can be very, very expensive. So the other thing we wanted to touch on briefly this morning is creating a roadmap. So once you have your estate plan all put together, it's time to make sure that you have a roadmap. That's what we refer to it at Shire, and we create roadmaps for our clients. The way to set those up, it's an informal letter or document which is going to guide your family in understanding and executing whatever plans you have, and to make sure that your wishes are carried out. So in your roadmap, you could list your assets and your liabilities. You could list important contacts. You could list where important documents are kept. You can even put in personalized notes. The roadmap is a way of capturing everything that somebody would need to know should something happen to you. And it's just a great thing to keep updated. We do our roadmaps in electronic form, and you can just keep things updated. You have, a new account, you can put that in there. You have a new contact, you can put that in there. Things change. If you have a safe or a safety deposit box, how to access that. So, we would have people come into our office after something happened to a loved one, and they didn't even know how to get into their computer to access anything that might be online. So it's extremely important that you have some type of roadmap to guide this types of situations should something happen to you. So we'd love to have your questions. If you have any, you can just drop them in the chat. And like we said, we are available anytime to answer any questions that you might have. You can call us directly, again, 847-955-9000, or please feel free to contact either Alan or I or both of us at Caren@shirelawgroup.com and Alan at shirelawgroup.com. And we really appreciate you taking the time this morning. And it's been a pleasure being able to present as well. So thank you.
Thanks so
I
much.
wanted to make the comment too for you that, and excuse me if you said something about this. I'm not sure you did, that it's very important to seek legal counsel for the proper documents and not go online, print forms out and be done, because the online forms are really very incomplete and they don't point on specifics. And can you touch on that, because they are available online?
Right.
Who get them online and do those quickly, because it's
right. So certainly you could go online and get these statutory forms for your healthcare directives, but as we mentioned, that in Illinois, unless certain powers are stated in your powers of attorney, your agents might not be able to act on those powers. And to Barbara's point, there's a lot of powers that aren't on the statutory form. And we have faced oftentimes somebody's come into our office who have used those statutory forms, and it's been an agent who is trying to do some kind of planning for a loved one, and they're unable to, because the power isn't specifically listed. So there are powers listed in there, but they're not as complete as we would like to see. And we literally have pages and pages of additional powers in there, including being able to designate beneficiaries and handle special needs trusts. And we even touch on digital assets in there, handling mail, handling credit cards, and doing some more planning for long-term care planning, like caregiver agreements and things like that. So, Barbara, to your point, it is extremely important that you make sure that these documents are done well, and that very important that they're done in advance while you're still able to have the mental capacity to put them in place.
And also when and if someone is in the hospital or you're in the hospital, whatever documents you sign there or sign to someone to be able to speak to the nurse or the doctor, those are not powers of attorney for healthcare. So some people will say, oh, I was in the hospital last week, and yes, I did sign those things. Well, that was for the moment in that hospital stay, correct?
Yeah, that's exactly correct. And also keep in mind that may not necessarily be convenient for you to sign anything, especially if they're wheeling you into the emergency room and you're unable to consider documents or sign them or fill them out at all. So having them ready in advance is a big advantage, because you'll have everything already set up, and God forbid you're taken to the hospital, especially in an emergency situation, you don't have to worry about signing stuff when you get there. It's already going to be taken care of. So that's a big plus. I will say too, with the online forms, we're not fans of that because we're lawyers and we compete with those services. But we do find that a lot of them are not filled out properly as well. So, I mean, some of these forms require a witness or witnesses, some require notarization. So sometimes that's not taken care of properly as well. So all of those things need to be considered. We feel that going to a professional, an attorney that you're going to trust, is going to be the best scenario in order to make sure that those things are in place.
Is there a state inheritance tax in Illinois?
Yeah, there's no inheritance tax, but there is an estate tax. So you have the federal estate tax, and then Illinois has a separate estate tax system that feeds off of the federal, but there's a lower amount. So there's a $4 million exemption per person in Illinois. And then the federal exemption is $11.9 million. So when you're talking about estate taxes, it doesn't really affect a majority of us, but it does affect a few individuals, wealthy individuals, and you want to make sure that you're going to an estate planner that understands how to plan properly to either eliminate or reduce the effect of those estate taxes. But there's no inheritance tax in Illinois. So somebody receiving money does not have to pay taxes unless it's going to be a retirement plan. Then we have an income tax consideration, because whenever you pull money out of a 401k or an IRA, somebody's gonna have to pay income taxes on that. That can't be avoided. But generally, as a beneficiary, there's no inheritance tax in Illinois. You don't pay any inheritance tax for money that you're receiving, just that the estate might owe estate taxes if it's a very large estate. But all of that stuff can be planned for and hopefully either eliminated or reduced.
Okay. Any other questions? This has been a really informative morning. As always, we always appreciate your time and help for ElderWorks. It's been a bunch of years since we've met you now. And thank you to all of you wonderful participants. You're just, we need you out there to spread the word and attend our these public presentations. Sometimes we do CEs. We do CEs for nurses, social workers, nursing home administrators as well. And we touch on a lot of different subjects. So thank you very, very much. And we'll see you all again soon. Thank you again, Alan and Karen and Emily, for all your assistance.
Thanks, Barbara. Thanks, Emily. Thanks, ElderWorks, for having us. We really appreciate it.
Thanks very much, everybody. Have a good day.
Bye-bye.
Bye-bye.